the ongoing war between HYBE Corporation and NewJeans involving allegations, leaked documents, and hundreds of millions of dollars at stake. Today, we're diving deep into one of K-pop's most explosive legal battles. NewJeans skyrocketed to fame in 2022, becoming one of the biggest girl groups almost overnight. But behind the scenes, a massive legal fight has been brewing that could determine the entire future of this group. So grab your favorite snack, hit that subscribe button, and let's break down this complex situation. Everything exploded in April 2024 when HYBE launched an internal audit, accusing Min Hee-jin of attempting to seize management rights, leaking trade secrets and confidential information, planning to steal ADOR away from HYBE using external investors, and leaking personal details about artists. Min fired back the next day, calling it absurd, and redirected the focus, claiming HYBE's group ILLIT copied NewJeans' entire concept. On April 25th, HYBE reported Min to police. That same day, Min held an emotional 2-hour press conference, showing text exchanges with HYBE executives and claiming unfair treatment. This wasn't just corporate disagreement anymore. This was war. May 2024, the court temporarily blocked HYBE from removing Min as CEO, a huge win for her. But by summer, things got worse. In June, Source Music filed a 500 million won lawsuit against Min. In July, HYBE terminated their shareholder agreement with Min. By August, Min was removed as ADOR's CEO anyway. Then NewJeans got involved. September 11th, the members held a live stream calling for Min's reinstatement and expressing concerns about hostile treatment. October 15th, member Hanni testified before South Korea's National Assembly about workplace harassment, claiming ILLIT's manager deliberately ignored her. October 24th, the real bombshell. A National Assembly audit revealed HYBE's weekly music industry report, an 18,000-page internal document with harsh comments about K-pop artists, including material suggesting they should discard NewJeans and start anew. HYBE's CEO apologized, but the damage was done. November 13th, 2024, NewJeans sent ADOR an official demand with a 14-day deadline. Reinstate Min as CEO. Apologize for workplace harassment. Take legal action on that leaked document. Address mistreatment. November 20th, Min resigned from ADOR completely. November 28th, NewJeans held an emergency press conference announcing they were terminating their contract effective at midnight. They cited breach of contract and destroyed trust. The next day, ADOR said the contracts were still valid. HYBE's stock dropped over $420 million in value. Throughout 2025, courts consistently sided with ADOR. In January, they blocked NewJeans from signing independent deals. In February, they blocked them from using the name NJZ. In May, they imposed 1 billion won, that's about $700,000, as a penalty per member for each unauthorized activity. October 30th, 2025, the biggest ruling. The court said NewJeans' contracts with ADOR remain valid through 2029. The court found that Min's dismissal didn't breach the contract. Personal trust in Min doesn't make her CEO position a contractual obligation, and the leaked videos and bullying comments don't justify termination. This was devastating for NewJeans. Let's talk numbers because they're staggering. If NewJeans walks away, the estimated penalty could reach 620 billion Korean won. That's approximately 441 to 467 million US dollars total, or about 124 billion won per member. How? They calculated each member's monthly revenue, 2 billion won, multiplied by the 62 months remaining in their contract. Right now, each member also faces a 1 billion won fine, that's $700,000, for each violation if they do any work without ADOR's approval. And if they leave, they lose all rights to past albums, existing advertisement contracts, and potentially even the NewJeans name. So can NewJeans terminate without these massive penalties? Under South Korean law, yes, but only under specific circumstances. First, material breach by the agency. When the company breaches a primary obligation, something so important that if the artist knew it would be breached, they never would have signed. Examples include financial insolvency, non-payment, or failure to perform duties causing great damage, like what happened in the TVXQ and K-BORA cases. Second, unconscionable contract terms. The landmark TVXQ case found 13-year contracts excessively long with unfair damage clauses. Third, breach of good faith. Both parties must fulfill obligations honestly and fairly. Fourth, mutual fault. If both sides violated obligations, penalties may be nullified. NewJeans' argument was simple. We didn't breach anything. "We did our best. ADOR breached the contract, so they should pay us." They claimed Min's removal created a management vacuum, workplace harassment and mistreatment, leaked confidential materials, and internal documents about discarding them. Interestingly, they chose not to file an injunction because their attorney said they had ample reasons and didn't want to wait through a long legal process. But the court disagreed with basically everything. The judge said, "The member's personal trust in Min alone does not establish that guaranteeing her CEO position was a fundamental obligation under the exclusive contract." Legal experts were mostly skeptical from the start, saying minor contract violations rarely justify unilateral termination, and that courts interpret these cases very strictly. So where do things stand now? Min Hee-jin is no longer with HYBE or ADOR. Criminal charges were dropped in July 2025, but she's still fighting civil lawsuits over shareholder rights. NewJeans is legally bound to ADOR through 2029. They can't perform or release music without ADOR approval. They're planning to appeal the court decision, but their relationship with ADOR is completely destroyed. They've been largely inactive since early 2025. ADOR and HYBE won all major court battles. They claim to have new album demos ready and are urging NewJeans to return to work. This case is setting major precedents. Can artists terminate based on personal trust? How much power do parent companies have? Should K-pop idols get labor law protections? Who owns a group's creative identity? Multiple artists, including 17's Seungkwan, have called for better treatment of idols. This has sparked huge discussions about mental health, power imbalances, and contract fairness in K-pop. Industry groups warned, if contracts can be terminated through declarations, who would invest in uncertain agreements? The big questions remain. Will NewJeans win their appeal? Legal experts say it's unlikely. Can they ever work with ADOR again? Trust seems completely destroyed. What happens to their career after this long hiatus? They won Billboard's Group of the Year in 2024, but can't capitalize on it. And how will this change K-pop contracts going forward? The HYBE versus ADOR battle exposes fundamental tensions between corporate control and creative freedom, between contracts and human relationships. Courts sided with contractual enforcement, but the human cost to NewJeans' careers and well-being is massive. Members have spoken about mental breakdowns and exhaustion. What do you think? Should contracts be absolutely binding, or should artists have flexibility to leave harmful situations? Drop your thoughts below. If this was helpful, hit that like button and subscribe for more K-pop deep dives. Thanks for watching, and I'll see you next time.